Right. So I seek your permission to leave, and
All right, Prof.
yeah, thank you. Thank you so
Thank
much.
you, Prof. Thank
All
you.
right.
Right. Okay, we restart. I mean, shortly that this is about the principles of consumer protection in e-commerce developed by the OECD in year earlier in 1999, but then revised and developed further in 2016. Yeah. So we have mentioned the first few elements. Now about confirmation and payment process. This is very important, yeah, brothers and sisters, because you don't meet online. I mean, you don't meet face to face. Some people, as I said earlier, they are very hesitant to go to online transaction for some reason, because they don't know if their transaction will go through properly. And especially you talk about to elderly, to some adults who never been in a very active use of the internet, they could not imagine how these things work. So a good e-commerce practice is to actually inform the users, inform the consumers how things are being done. So, step by step. Once you place the order, then we are going to give you a message to confirm. That's why in most of the things, and you download anything, online and so on, before you really finalize everything, either payment or a transaction or exchange, they may ask you to confirm. Are you sure, or do you want to confirm? Like in online banking, after you put all the details and then you click OK, then there is this page in order to confirm. Do you want to confirm this? So this is necessary. And of course, this e-commerce principle is not a law, but then uh, it is actually there in Malaysia now. It is made a law by Consumer Protection Regulation 2012, that this process, this step of confirmation must be there. Yeah. So this will inform the users when is it that they're going to be bound afterwards. Yeah? Meaning the moment you confirm, the click yes, I agree, I confirm, by then you are bound. Yeah. So that by then, before you really click that, then they actually give you an option to look at some information, some terms, looking back and checking if everything has been done correctly and so on. So this is a very important principles. Yeah. Next is dispute resolution, of course, and the redress. Yeah. It is very important because a lot of things can happen. Yeah. Uh, Especially online, because I remember my I think my daughter or my son, I don't know which one, but they just bought something online. Then the moment they receive it, he realized that this is not exactly what he thought he would get, in terms of get the get up of the product, or the size. Even though the size might be there, but he really was not really aware of how it really looked like. So the moment he received the thing, then you realize something was not exactly right. So some people would want to know, how do I get a redress? How do I want to get, if it is any, if any, to get redress, to get refund, to get, solution to this problem. So a good e-commerce service is to inform you in advance, yeah, about this kind of thing, and also to really allow this kind of situation. What happened, recently I was just informed, because my friend was recently launching a restaurant. It is an Indonesian food restaurant, yeah. Soto, yeah, soto restaurant. So they wanted to use the Panda Food service. So after some communication, Panda Food then send my friend the terms, yeah, the terms of the contract, and it is all in very legalistic term in English and everything. So he was not really able to comprehend the matters. So he gave it to me. He wanted me to read all those. So I checked, of course, step by step, line by line. It was my moral duty to inform him what if there's anything wrong. Then I checked some matters, like what happened if the consumers are not happy with the food that they got. For example, it was a wrong food, or maybe the quality is different, or maybe the quantity is different. There are a lot of things, or a lot of situations or circumstances in which Panda Food would allow consumers to get back to them in case they are not happy, yeah, with the service. And in such a, of course there will be some assessment, and if proper, then the vendor, which is the restaurant owner, will have to do some action, either to resend a new food and so on and so forth. So this is very important, yeah, the dispute resolution and the redress. And last but not least, which is which is the addition, from the previous principle, is what? Privacy, security, and consumer education. These are all very important area uh, that are crucial to protect our consumers. First, about the privacy, because data is now increasingly used and overused, and to some extent being abused. Yeah, so this that's why now every e-commerce will have to consider the privacy policy. Yeah, wherever you go to, any website lah, then you will find there is a privacy policy, and then security as well. Security meaning the security of data, security of the transaction, security, safety of children. They are all within this terms. So every website e-commerce website must have that. Otherwise, meaning they are not protecting enough. By privacy, for example, they will inform what do they do with the data they collect. Are they going to keep it, because the law says you have to keep it well, and once you are done, you have to dispose of it. You must not keep it unnecessarily. This is what our law says, yeah, in Malaysia, Personal Data Protection Act. And you must never sell the data to other people, or allow other people, unauthorized people, to use the data. This is illegal. Yeah, this is illegal. That's why all these policies will have to be put in the privacy policy and privacy terms. Also, to some extent, ultimately, we all will have to consider, contributing to the consumer education. The government, all stakeholders, the government, the industry players, yeah, as well as the consumer associations. We have to keep on, and you students as well. You now take part of this. You guys who already elect for this consumer law elective, then you have this duty, to to educate, our people about the risk and benefits of e-commerce. So this is a set of principles from developed by OECD, and had inspired many laws in the world, to be included in their legislations. Now in Malaysia, how is it? Because when we say in Malaysia, maybe not necessarily, maybe for the purpose of further research, you can do some analysis to what extent all these principles, as I said, had been adopted in Malaysia. But of course, this is a different research altogether. If any of you is interested to do research, you may want to do this research. How much these principles of OECD had been adopted in Malaysian law? We can do like survey and analysis, whether or not it is there. So I'm not doing that here. So I just pick you several legal issues, which are very pertinent, for our electronic commerce in Malaysia. First of all, as you see there, left top, the top left here, on the issue of admissibility and enforceability of e-transaction. This is very important, but I must say this is quite settled with the legislation of the E-Commerce Act 2006. So before 2006, it was not very settled. People do not know to what extent, this email, this blog or website transaction can be considered as a paper document for the purpose of contract. So with this Electronic Commerce Act, as you will see in the next slide, it actually helps, all of the doubts, so many doubts that we have had for e-transaction. Now they are becoming legal, equivalent, as well as admissible in courts. And this is also supported by Evidence Act 1950 in Section 90A. You can refer to Section 90A about the admissibility of computer-generated documents. So before this, computer generated documents means you may still need to print out the email. For example, you do transaction on email or your SMS and so on, so this needs to be printed out and given a signature and so on. But now it is no needed. It's not needed, meaning the document as it in its original format, which is in electronic or digital format, is considered as an original document already. So and a lot of other reforms have been made by this E-commerce Act 2006, with the objective of ensuring the legal certainty for e-transaction. Then you go to the right, top right, yeah, penalties for abuse, yeah, for those people who are misusing the e-commerce transactions, doing criminal activities. Remember, we have this Computer Crimes Act 1997. So for those people who sabotage the computer system or to intrude some computer system, or some people who modify some content of the computer system, or for example, someone who misuse other people's account or password. So all this can be criminalized under the Computer Crimes Act 1997. Yeah, more things of this are being studied under the IT law. Yeah, IT law with Dr. Mayudin. Yeah, in another elective. So it is good to try, going to this class as well to complement for this area. Okay, then penal code would still be useful because all these cyber fraud issues, yeah, the fraudulent activities in the internet, people or police still use penal code. Yeah, the provisions of fraud and the penal code would still be used in order to protect consumers who are being cheated, who are being defrauded, by people. Including by fraudulent advertisements. Yeah, this can also be can trigger the penal code. And then Communications and Multimedia Act is also useful, is especially for those who are misusing the content of the internet. Yeah, not as not very pertinent in terms of electronic transactions, but to some extent it may be useful as well. Then you go right, bottom right, there's consumer protection law. So of course the consumer protection in 1999 is very useful. For your information, right, this CPA 1999, when it was first legislated, actually the first version of the law of the act, it says that it excludes electronic transaction. It excludes the transaction processed by electronic method. In other words, yeah, when it was first legislated and enacted, the CPA 1999 was not applicable to e-commerce. But then this particular provision was amended, yeah, and now we are very happy because the CPA 1999 has now been amended to include the e-commerce activities, which means all the principles of the CPA 1999, yeah, will apply, including all this the implied terms, the unfair terms, and then on this defective products and so on and so forth. This all will be applicable to electronic transaction. And then we have Consumer Protection E-Trade Transactions Regulation 2012. I'll show you some key points from this law, but one of the most important key point of this act is actually it talks about, or it requires the business player or the e-commerce player to record their transactions, and also to have this confirmation process and also refund process. So these are all within this regulation 2012. And last but not least is the regulations on the data protection as provided in the PDPA 2010. All right. So this is the overview of the e-commerce legal framework. The next slide will show you some key issues. Is there any question before I proceed? Okay, no question. Then I'll proceed with this. Okay, first we look at the E-commerce Act 2006. I just highlight to you the key issues or the key milestones that the effect of this E-Commerce Act 2006 is very tremendous. It actually helps the digital economy of Malaysia. It helps the consumers. It helps, you know, e-commerce players as well as consumers, to have a better relationship. We have a better relationship in terms of electronic commerce activities. So, among others, for example, in section 5 and 6, it provides for the legality and admissibility of electronic message. What is that? Your electronic message, the one that you send online, by mobile phone, by internet, you know, in your whatever form and platform, you know, the social media or email or on my blog, like my blog, and anything that you create a website, all these are considered electronic message. So this electronic message is recognized legally and also admissible in court of law. So this is a very clear declaration by the ECA 2006 in order to ensure, you know, the protection of consumers as well as the you know, the eventually the sustainability of the digital transactions, because without it things are becoming uncertain and can be challenged from time to time. Then in section 8, right up right here, the legality and equality of paperless documents. So in the past, without this provision, people thought that if they want to put legal effect on their transaction, then they have to print out all these electronic message, like the email has to be printed out and you stamp, put a stamp on it, and then signature, hand signature. Now no more. All these are not necessary as long as you can show that this data, for example, the data still remains in your email system or SMS system. As long as you still can show that this message is not corrupted, it is still in its original format, and it can be retrieved. So that is good enough to say that it is original, legal and equal, just like paper document. Okay, next in section 7, right down right here, formation of e-contract, offer and acceptance. You guys must still remember during your first year studies about offer, acceptance, right? Invitation to trade, offer, acceptance, and then consideration, and then the invitation, intention to create legal relations. All this in your first year topic. So actually, what this law was trying to confirm that all these principles are still applicable, are still relevant in terms of e-transaction. So just because you don't see the people face to face, it does not mean that there is a different way of making contact. You are still making an offer, the other person making an acceptance, or the other way around, whichever applies. So still offer must be there and acceptance must be there, and then once it is once they are in concordance between one and the other, then there is an agreement. So with this, it clears the doubt, that your whatever you do even by SMS, you can make a binding transaction. Then the originality of document also, I think I mentioned here that even the electronic message considered original. So I realized I have not changed some of the icons here, so sorry for that. I forgot to, you see some icons inside here, they are not really suitable to some points, but it's okay, just for the purpose of illustration. So we have this one case in 2014 where Yam Kong Seng versus Yi Weng Kai. So one of the issues in this case was it centers on the issue of whether or not an SMS message could be considered as a binding promise. There was actually conversation between them about paying that, and the other person says, okay, I will pay. As you see here on this slide, this is what exactly the defendant was writing. Eddie, sorry, here your father death. You always use this short form. A lot of short forms nowadays. Sorry, here your father death. Regarding the loan, repayment, regarding the loan repayment, sorting soon. Not to worry. Now I'm in UK, London next week. Wow. So this meaning it was understood that next week he will actually settle it. So based on this message, the plaintiff argued that defendant had promised and then he did not really pay, he did not fulfill the promise, and then based on that, it could be considered as a breach of promise. But then the defendant argued, come on, it was just an SMS, just a very short message, thing, and you cannot treat it as a proper promise. But then the court disagreed with that, and in fact decided in favor of the plaintiff. Yeah, saying that a message from an SMS with all the attributes. Yeah, attributes means as long as you fulfill all the criteria from Section 8 of the E-commerce Act 2006, then which is what? Which is accessibility, intelligible. Accessibility means you can access it, you can actually retrieve it. Yeah, you can people can see it. Yeah. Second, intelligible means it is understood. Yeah, as long as no matter how short, yeah, the message is, as long as it is understood, then that's it, that's okay. And then extractable for subsequent reference, meaning it can be open now, it can be open tomorrow and in future. So in other words, the system remains possible for people to get back to it. So these are the requirements according to Section 8 of the E-commerce Act, by which SMS would be considered valid and equal to a binding promise. Yeah. So the court say it is such an electronic message is as good as in writing, as what you write on paper proper. So this is one of very important principle where the court recognize, yeah, the legality of the, which means now this is very important for consumers, of course, meaning no matter how things are being represented, as long as it is in whatever format and platform, then it can be considered as binding promise. Then in this Consumer Protection Regulation 2012, okay, as I mentioned earlier, this is a regulation under the CPA 1999. Yeah, so there is this sub regulation or sub law, we call it subsidiary law. Yeah, among others, one is there is a need for disclosure of identification. So if you are doing e-business, e-transaction, you must disclose who you are. Yeah, what the name of the person or the company behind it, and then the registration number of the company, and so on. Second, you need to maintain the business record for 2 years. This is for the purpose of tracing and the maybe if any dispute happens in future. Yeah. Third, the business or the e-commerce must provide for rectification of errors, because sometimes these consumers, they make errors, when they place order and then they put their identification, their identities, or when they do payment, sometimes error happens. So there must be some mechanism that the consumers can inform the e-commerce, the business providers or website operators, that they made a mistake and they wanted to correct it, to rectify it. So this must be provided, yeah, by the business player. Also, then acknowledgement of receipt. This is very important. So you are not being very hesitant after you click payment. Okay, then you cannot sleep the whole night. Did my payment go through or not? Was it accomplished or not? Yeah. But at least if you get some acknowledgement, okay, we receive your payment, or your transaction is ready, now we are in the process of confirming with the bank, for example, at least there is some acknowledgement of the process, then it is good to, in order to serve your consumers, so to clear their doubts. Yeah, so this is under regulation 2012. Now we talk about PDPA. I think this is among the last part I want to mention. As you may have heard about this act, yeah, this is actually not only about consumer protection, but among any business throughout. Yeah, actually it provides new sets of requirements for whoever process data. So I mean, all business are processing personal data, right? Personal data means data about individuals, about their identities, about their families, about their health, about their education, about their transaction, about their address, about their location, movement, and so on. Oh, these are all personal data. So I'm not going to cover, I mean, to discuss all those conceptual clauses or provisions, but I want to go direct to this gist of the PDPA. There are 7 principles that need to be um, fulfilled, yeah, by e-commerce player or if e-commerce providers when it comes to collecting data. Because these people, when you, for example, place an order on what Shopee, on Lazada, right? Of course, you are collecting the data. Either you, sorry, of course, they are collecting your data. You know, either the data is collected from the data that you write in the form, or without you knowing, actually they already collect your data the moment you open their website. You know, start to search on their website. There is this method mechanism to collect data already. Yeah, because there is this file named cookies, yeah, cookies file, which is able to actually detect, yeah, your behaviors on the internet and able to build a profile of you, and then this information will be sent back to, I mean, to those origin of this cookies file. For example, you open what Shopee, and then you actually retrieve data. Have you ever experienced this? Yeah? After, for example, you wanted to buy something, apa ya? You wanted to buy dietary vitamin lah, supplement. Then what you do, you browse, yeah, you browse here and there lah in the internet. Okay. Then after that, whenever you, let's say the next day, whenever you open or browse any website, let's say to read story, to read news, there will be some advertisements which are suited to you, especially on the similar things that you have searched the earlier day. Then
Yes,
you
sir.
will be shocked. And this, does it happen to you? Yeah. Then you will be shocked. Why is it that after I searched it yesterday, it looks like the whole, this Facebook, Instagram, or even websites, as if they know that I searched something, yesterday. Now they offer me with this advertisement. That is how the cookies are doing. Yeah, the cookies actually manage to detect what is your preference, your behavior, what are the things you're interested in, what are the websites you're visiting, and then this file actually resides in your computer or in your mobile after you send all those materials, after you visit all those websites and materials, and then that same files of the profile will be sent back to those people who send this cookies file. So this is unregulated before this, but because of the PDPA 2010, any business commerce players or e-commerce players, when they want to use this method in order to collect data, then they have to inform. Yeah, they have to inform. But now the problem, consumers, again, is the issue of education and awareness. People don't care. People don't care. They got this a warning and warning information and so on. People don't care. They simply say yes, 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 no problem. I agree. I accept. I confirm. As long as you want to use the service. For example, your mobile phone. I think most of you have been downloading or installing apps for your mobile phone, isn't it? Is there anyone here, and I'm just curious to know, is there anyone of you, my students here, who ever bought something to install into the mobile? I mean, bought any apps? Has anyone bought any apps to install into their mobile in the past, let's say, 1 year? Is there any?
Yes, sir.
You have. Okay, good. What, I mean, how many apps you actually bought?
Just one.
Just one. Throughout 1 year, 2 years?
Throughout the whole year, 1 year.
Yeah. You see, so low. We still get people who care to buy for the apps. Maybe because the apps are so, restricted for what? Why? What is the reason you bought that apps rather than getting the free ones?
Because of some premium features which are locked behind the paywall.
Okay. You want to get that premium services, or otherwise you will just get the free one, isn't it?
Yes, sir.
Okay, okay. You are, of course, in this situation, there is always an exception. But as you see, so far, only one person or maybe few others who did it, but only once in a year. So you see, most of us, the rest of us, you know, you have like how many 20, 30 apps in your mobile phone. You never paid them. You don't pay a cent for them. But remember, you are not paying with money, but you are paying with the data, because you allow these apps to have access to your mobile phone, yeah, to some types of data, either to, you know, pictures, to the database of contact lists, or to the movement and location data, and so on and so forth. The, Now the issue is we never care, you know, the moment you want to install, then they ask you, you agree to allow access to this. Yes. What else? Is that a default? It should not be a default. I mean, you should really consider, you know, well, sometimes we don't have choice. But if we really don't have choice, then we have to go on the minimalist mode. You do not have two or more apps for one specific function, isn't it? For example, for GPS or navigation, why do you need for two or three, you know, apps? Waze ke atau apa, Google Map. You don't need two. You just take one. At least you go on minimalist mode. You know, then at least you reduce, yeah, the risk of sharing your data unnecessarily to other people. Also for any others, and for example, you want to buy Quran. No, we have so many Quran apps as well. Muslim Pro, people are now noisy about Muslim Pro. They cry about the issue. So you have lots of you know, maybe it is good that some people want to be, you know, very compliant, Sharia compliant, you know. So whenever they see any apps relating to Islamic knowledge um, applications, then you install. Yeah, then you install 1, 2, 3, 4, 5. You have like 10. You have one for Quran search database, the other for Hadith database, the others for whatever others. You know, do you actually really need it? I must keep on asking these questions to all of you and to all of us all the time. If you don't, then remember, because you are paying with your data. Yeah. So these are things that need to be highlighted. So I want to show you very quickly. One is about consent. I mean, these people have to get your consent. That's why you do some ticking and all that. Second, they must make sure, and it's still within the general principle, yeah, section 6, they must make sure the data is only used for specific purpose. So they must inform the purpose. Second, there must be notification and choice. So that's why now privacy policy is a must. Yeah, you go to any website, any company having a website, they must have this privacy policy, because they need to notify consumers. Yeah, they need to notify consumers. Third, it's about disclosure. In other words, it says that you must not disclose the data of individuals, of your consumers or clients, except for the one that has been accepted or consented. You cannot simply disclose to other people unnecessarily, except for example, law enforcement. Yes, for, you know, public purpose. You know, there is the law says about this, but generally speaking, no, you should not disclose to any third party. Sorry. Next is uh, next is security. On the security of data. So every company or every they call it data users, like the name, must ensure how they protect the data. So they must highlight how they apply the encryption, how they apply the access limitation, and how they distribute the access to people, and so on and so forth must be there. Next is retention. Retention means the data should not be retained longer than necessary. For example, you have bought something on you have done some transaction online, but you mean it to be just one off transaction. Yeah. So so if this is done, meaning there is no more need, yeah, for the e-commerce owner, to the website owner, to collect to retain your data. Yeah, unless if you sign up, you know, like this. I think most of this Traveloka, yeah, Grab Food, Panda Food, you need to sign up, right? So as long as you sign up, they will still retain your data. But let's say now you want to sign off, you want to delete your account with them because you are no longer going to use them. Then the moment it happens, then these people should no longer use or retain your data. That is the principle of retention, yeah, because no more business. Okay. Next is integrity. That means that any data which is collected by the website operator must be ensured to be accurate. The data must be accurate and up to date. And last but not least is access. Access here means very important for consumer protection, that we should be able to get access to our data. Yeah. In practice, for example, suddenly you receive calls, yeah, from some unknown people, yeah, 2-3 times you receive call. Then you every time you ask, where do you get my data from? Where do you get my data? Then they will mention, oh, we are agent of this company XYZ, maybe your telco company. Then you realize something was wrong with my telco, and it looks like they are allowing other people to access your information, your number. So now you want to access your data at your telco, yeah. Then you tell them or you communicate with them, I want to know what you do with my data, what data has been kept about me, what data has been used for what purpose. And this is all this is all provided under this section 12, where these people have to provide the access to consumers. And also there is what we call as right to access, yeah. Because of this, there's a right of access under the PDPA 2010. Yeah, so this is all the 7 principles important to ensure that the data is being protected and secured properly, so as not to be abused, yeah, by the e-commerce players. Okay, please, this one among others, yeah, we have rights of data subjects. Okay, different sections. You see, PDPA is very huge. Among others, it provides rights of access to personal data, yeah, then right to correct personal data, and then right to withdraw. Yeah, for example, you already agree before, then you want to withdraw. Yeah, that is in section 38. Then right to relating to direct marketing. For example, you don't want to be subject to direct marketing. Section 43. Let's say, for example, you already agreed before when you sign up for any company lah, telco ke, astro ke, internet, whatsoever, then you say that, okay, I agree that my data can be used for certain purpose. And then later on you regret and you are giving a you giving a new thought to it, and you realize, no, I don't want to allow this time, especially relating to direct marketing or even for any purpose, then you actually can go back and withdraw your consent. Yeah, that is allowed. Then right to prevent distress or damage, and also right relating to sensitive data, section 40. So please, you can go further. This is just like a key eye opener, yeah. Because in my class cyber law, I teach this for at least 2 times 5 hours, 10 hours, yeah, for this one. This is a master class, so meaning a lot of things have to be covered. But of course, for this one, it's just an eye opener about these rights under the PDPA. Okay, brothers and sisters, these are the last slide, I think. We have covered a few issues about the E-Commerce Act, then Consumer Protection Regulations, as well as the Personal Data Protection Act. Here are my key takeaways. Number 1, fundamental principles of consumer protection still apply in the e-commerce. Yeah? Just because you change the medium doesn't mean that now we have new principle. No, actually, whatever principle that we learn under the offline and the conventional method of business, yeah, would still apply in the e-commerce or e-business. That is very clear. Meaning it is nothing new, except that medium is new. Second, as the consumers increasingly migrate from the offline to the online, then the law has to adapt. Yeah, now we need few specific laws for the purpose of electronic commerce. And that's why the law of electronic commerce is far from settled. Yeah, we have seen a lot of challenges involving artificial intelligence, involving smart contracts, involving issues of data synchronization, data aggregates, big data, all this will require more efforts by our legislatures or whatnot now. Cryptocurrency issues, digital payment. I mean, we have many, lacunas, here and there that we need to keep on, inventing on this area. Then business, legal, and technical stakeholders play critical role. In creating any. If you want to, let's say, you are in a government, in a legislature, you want to create new laws or think about new laws in e-commerce, then you must involve all these important stakeholders. You need to understand about the business in e-commerce situation. For example, people have been talking about how to tax YouTuber. As a matter of fact, these people, who are maintaining a content, online content like on YouTube, on Facebook, on Instagram, they earn really big money. They earn really big, much bigger than the normal professions that we have seen in the past, which are now subject to many rules, many taxation rules, and so on. But now these people who are making money online, they are virtually free from any restrictions or rules or taxation and so on and so forth. So you want to catch them, you want to subject them to these new rules, then you better be very, very careful, or less you will be simply creating a law which will in future cripple the innovation and then further slow down the digital economy and so on. We don't want this to happen. Next, data protection is crucial for future e-commerce because more and more data are going to be processed, and therefore we need to strengthen our personal data protection law. And I think it will be very important for all of you here to understand a little bit about the PDPA and to learn the issues coming. And last but not least, e-commerce is borderless. So should the protection should the protection be? Meaning the protection should be borderless as well. We need to gain, international efforts together to protect our consumers, because consumer in Malaysia, vendor in Singapore, and then the seller in America, for example, how will you create a very powerful protection unless you have this international efforts? So brothers and sisters, that will be all from me. Thank you. You can drop by at my website, sonnyzulhuda.com, to get the slide, or maybe you want to check my earlier postings about data protection law, cyber law, and any other related issues. That's it. Thank you. Any question? Are you still there?
Principles of
Yes, please. Adam.
The principles of digital evidence, just now under the E-commerce Act, regarding the recognition and the admissibility of online messages. Are those principles exclusive or unique to e-commerce law, or are they like adaptations of actually a general principle but in the area of e-commerce?
Look, these principles are considered as the enabling law. So anyone who is doing these electronic transactions, in any activities, you can use the principles of this law, the legal principles under the ECA to be applied in any others. And because this, according to this ECA, Electronic Commerce Act, it applies to any types of transactions. Maybe the transaction is regulated under what? Under Banking Act, or any banking law, for example. Or maybe the transaction is regulated under sale of goods or any others. And they use electronic method. So now we still can apply the principles under the ECA to be applied to these transactions. However, under the ECA, there are 4 types of transactions which are not covered by the ECA. That means you cannot use the principle of the ECA. That includes the making of the wills, and then the negotiable instruments. So you cannot have a digital check, for example, digital check is not yet legally approved because under the ECA there is this exception. Yeah. Then what do you call this? Power of attorney. Yeah, power of attorney, wills, and wasiat, and then this what I mentioned earlier, the negotiable instruments. Yeah, so the ECA does not apply to this.
Okay, sir.
Okay,
Thank
Adam,
you.
right.
Yeah. Thank you.
Any other question? Yeah, this is a reunion for some of you who were in my class like 2 years ago, I think, or maybe more. I can recognize you. Adam, you were in my thoughts classes, right? And some
Contract,
others as
sir.
well. Oh, contract. Okay. All right. If there's no question, nothing, then we have one. Okay. Ahmad Ibrahim.
I have a question regarding the email. Does it consider as instantaneous or non-instantaneous means?
Okay, you are still trapped in this discussion about whether under this postal rule and whatnot in the conventional method of communication. You just need to refer to the meaning of instantaneous and not instantaneous. Yeah. In most cases, and in fact by design, email is not meant to be instantaneous, right? Email is not designed to be instantaneous. So as I said, then it will be treated as non-instantaneous, no matter how small the gap of the communication it is. But in my opinion, this is no longer really relevant for today, unless you refer to specific regulations, which makes it very important or relevant to differentiate between instantaneous and non-instantaneous. Okay. But in my opinion, or in the way how email works, it is not meant to be instantaneous, right? Ahmad Ibrahim, you are the one who was running for LOSOC presidency. Was it you?
Yes, Doctor.
So what was the outcome?
I lose.
Oh, okay. I know, because I just saw, I think, the poster a few days ago. Yeah, all right. Well, congratulations for running. I believe it must have some, there's a secret. Yeah, we never know. Why you lose, you will know better after this.
Thank you, Doctor.
But the issue is just don't stop fighting for good deeds. Yeah, whether it as a president of a LOSOC or as anything else, there's always a way to do it differently. Do we have any other question?
Sir,
Yes, please.
I have a question. With regards to the enforcement, for in the e-commerce setting, do we have any specific enforcement agency that ensure compliance of the rules, or is it solely based on the consumer reporting themselves if they see any violations of the law?
Yes, under the ECA, there is no specific agency empowered to enforce. Okay, so as we said, it is an enabling principle. Even though there is, of course, the specific ministry who takes care of this legislation, which is what the Ministry of the same ministry that deals with the consumer protection. They are the one who takes care. But in terms of enforcement, yeah, if it is something to do with the consumer issues, then you go to this same enforcement method. If it is relating to KPD and HPP may have some role, but you may want to go to police for anything related to the criminal activity of e-commerce, yeah. Or if it involves the like cross reference with the Communications and Multimedia Act, then you have to refer to the MCMC. Yeah. Or if it cross refers to the Data Protection Act, then you have to refer to JPDP. Yeah, JPDP is Jabatan Perlindungan Data Pribadi. But if it is purely about consumer issues, then you know that you can refer to the KPD and HAP. Yeah. So no specific enforcement for the ECA. Any other question?
So in that regard, do you think there should be some sort of reform in enforcement, but even though like it's all scattered all over the place?
I
there should
don't
be-
think so. I don't think so because again, it is the way how the ECA is legislated. It is in enabling principles. Yeah, it is an enabling. It is a set of enabling principles which can apply to many types of transaction or business or industry. It may apply to banks, for example. Then you have the Bank Negara to refer to. So it is. I don't think we need reform in this issue to have a specific enforcement authority for many things which are already having their own domains. Yeah. Yes. Anything else? Okay. Then I will wait no more. Thank you for participating and wish you all the best. Yeah. Let's recite Surah Al-Asr to conclude this session. Bismillahirrahmanirrahim. Wal asri innal insana lafi khusr illa alladhina amanu wa amilus salihat wa tawassaw bil haqqi wa tawassaw bis sabr. Thank you. Prof Mushera said we can leave after I finish my session here. Assalamualaikum warahmatullahi wabarakatuh.
Thank you,
Thank you,
Doctor.
Doctor.
Thank you, Doctor.
Thank you, Doctor.
Right.